I'm going to present Pietro Dunn, or Dan, I'm sorry if I can spell your name right, Dan, Pietro Dan, and he is PhD candidate in Law, Science and Technology at the Universities of Bologna and Luxembourg. He's also an academic fellow at the University in Milan. His research basically focuses on the relationship between constitutional law and digital technologies, with a specific eye on a platform governance, and his PhD thesis addresses to hate speech, governance and content moderation policies in the European Union.
And personal interests include good food, true crime broadcasts, and queer pop culture.
So, good evening to all of you. I am aware that it's 6 in the evening, you've had a long day, and probably talking about law is not exactly the first thing that you would like to do at this time. So I'll try and keep it a bit shorter and cut maybe some of the slides, especially the more technical ones, okay? So it might be a bit lighter, the conversation. So I am Pietro Dan. I am a PhD student from Bologna and an academic fellow at the University Bocconi in Milan. And I will talk to you about some of the legal challenges that we have with respect to the governance of hate speech, especially from a constitutional law perspective and a human rights law perspective, and most notably, I will take an approach, a European approach, so I'll try and give you a little insight on the measures that the European Union is currently taking right in these years as a way to face the issue of hate speech online on digital platforms. So first of all, I have reported here a definition of what hate speech is. Defining hate speech from a legal perspective is extremely difficult, especially if we want to have a general overview of what is hate speech, generally also on an international panorama. That is because all countries will have different notions and different approaches, legal approaches to hate speech. Also, generally, there are basically no laws around that talk about hate speech as such. So you will find that legislations across Europe concerning hate speech generally tend to talk about incitement to discrimination, incitement to violence, dissemination of or propaganda of ideas based on ethnic superiority or racial superiority. That is, for example, the case of the Italian Criminal Code. However, this is a definition from the European Commission on Racism and Intolerance, and is, in my opinion, one of the definitions that encompasses all the, in general, the approaches that could be taken by the law to counter hate speech. So, hate speech, this is a recommendation that this body of the Council of Europe gave to member states of the Council of Europe, which is not the European Union, but I won't go into that because I don't want to bore you too much. This recommendation talks of hate speech as one or more particular forms of expression, and there is a long list of potential conducts of forms of expression: advocacy, promotion or incitement of the denigration, hatred or vilification of a person or group of persons, harassment, insult, negative stereotyping, stigmatization, threat. The common aspect of this is the sentence that, the words that you can find underlined, that is, hate speech is always based on a non-exhaustive list of personal characteristics of status that can include race, color, language, sexual orientation, gender identity, disability, age, and so on and so forth. Then again, it changes from country to country. Just to bring again the example of Italy. In Italy, we have some legal provisions, but only concern discrimination based on race, ethnicity, and religion. So we've had a big debate in Italy, the Italian people will remember, just a couple of years ago on the so-called Zan, DDL Zan draft law, which aimed at expanding the scope of the relevant provision, Article 604 bis of the Criminal Code, also to sexual orientation, gender identity, disability, sex, gender, but it did not pass. Just a moment before, okay. Now, of course, the imposition of restrictions, of sanctions, especially criminal sanctions, creates a huge problem with respect to constitutional law. That is because imposing such restrictions, these sanctions, necessarily entails a limitation of a right that is constitutionally recognized. It is recognized at the international level, that is the right to freedom of expression. So I have identified here some of the reasons, of the rationales that could justify the imposition of hate speech restrictions by the state. I don't know whether I would like to ask, what do you think, how can we justify from a human rights perspective, from a constitutional perspective, the adoption of, for instance, the punishment of incarceration based on the expression of certain viewpoints? Can anybody think why it could be constitutionally admissible to adopt such restrictions on hate speech? Yes?
I'm thinking like free speech, yeah, is the right to say, express yourself, but I think we could open here the debate that is it free speech if you're hurting someone else when you're saying it, or is it just hate?
Any other opinions?
From a constitutional point of view, I thought about the, I don't know how to say derecho, right?
Right.
Right of honor in the Italian constitution.
Mm-hmm.
So to protect that.
Precisely. Yes, that's also a right which is protected also by the crime of defamation, for instance. So, of course, yes. Any other ideas? Okay. So, literature on the topic has identified a variety of reasons why it is considered we could justify the imposition of such restrictions on forms of hate speech. So one reason is basically the prevention of crime, disorder, violence. So the argument is, if hate speech has the power to make the audience commit crimes, for instance, hate speech against the Muslim community can push the audience to commit violences against the Muslim community, then that is a likely justification to impose restrictions on freedom. Yes?
Yeah, that's how the hate speech laws work here. It's only considered hate speech if you can prove that what was said can affect in a harmful way, like push someone to commit a hate crime. And that's where the debate comes, that even if you aren't motivating anyone to hurt someone in a physical way, hate speech is still harmful, but that's a whole other debate.
Yes, that's precisely an example. So in many jurisdictions there is actually this condition by which it is the crime of hate speech is considered a crime of danger, of concrete danger. So you have to somehow prove that there is a concrete danger that the hate speech is somehow internalized by the audience and has led to the commission of other crimes. But there are other potential justifications that have been brought up by literature and also by some European courts. So for instance, the protection of the individuals from physical or psychological harm. And this does not necessarily entail the commission of violence because of hate speech, but the fact that the simple act of hate speech has a direct impact on the subjects that are targetized. There have been studies, for example, that people who are victimized from hate speech, racial discrimination and so on, tend to be more subject than others to, for instance, strokes, to heart conditions. So hate speech can have a direct effect on the health of the people who are victimized. So in that case, we can have a further justification. More in general, a third justification, that is, we could say the one which has been adopted in particular by the European Court of Human Rights, is the protection of the dignity of the targets. So this means that the act of hate speech entails by itself negation of the right of the targetized people to dignity and to equality, the right to equality. And therefore, the utterance of hate speech determines a violation of the principles that govern our democratic societies. So the fact of speaking, of uttering hate speech content determines, we could say, a sort of a hierarchy in society which is completely at odds with the values, the constitutional values that characterize our society. But beware, these are potential justifications, but not everywhere in the world these kinds of justifications are welcomed. If we think, for example, of the United States, in the United States we have the idea that even hate speech as such is protected by the First Amendment. That is, by the provision of the US Constitution that protects free speech. The Supreme Court of the United States has basically said in a decision from 2017, Matal Vitam, it has stated that it is actually one of the greatest prides of US constitutional law, the fact that the Constitution protects even the thought we hate. By that meaning that under US Constitution, even hate speech is protected. So just to let you understand how, from a constitutional perspective, imposing sanctions, imposing restrictions on hate speech is not as straightforward as we might think. Okay. Sorry? Okay. So, moving forwards, what I've said, what I've spoken up to now is valid in general for the topic of hate speech. But we are talking here about online hate speech, notoriously. And it has been studied, it has been argued by many that online hate speech entails additional risks, additional problems, as opposed to normal, to traditional offline hate speech. Anyone who might want to jump in on this and, I don't know, may have some ideas about what is the issue specifically of online hate speech as opposed to offline hate speech? Any ideas at all? Why is it more of a problem? Why can it be?
Because everything online it's anonymous, so you can just hate whoever you want and say whatever you want, thinking that you won't be punished because people don't know your name, don't know who you are, so it's easy to hide behind a user.
It's precisely that is one of the reasons. Any other ideas?
On the internet, hate comments pile up, and if you see someone has already commented something hateful, it's more motivating to express that hateful opinion because you feel supported.
Absolutely, absolutely. So that is absolutely true. So there are a variety of reasons, okay? Now, here I am referring to some reasons that have been outlined by a 2015 UNESCO report. There are, according to this report, there are 4 main reasons why online hate speech is more problematic than offline hate speech. First, we have the issue of permanence, which is basically the capability of hateful content to thrive online and spread across the internet. And this can be determined in great part by the structure, by the functioning, by the architecture of the means we have. So for instance, as was said today, earlier on, Telegram is a huge problem because of its rules, of its internal rules, privacy rules, and so on. It makes it a perfect environment, a perfect place for cyber cesspools as have been defined to develop, so to have hateful content thrive on it. A second characteristic is that of itinerancy, that is, of course, you will understand what it is. It's the capability of content, of moving across platforms, of moving across websites and so on. And so even if you take down an illegal content, harmful content, then it's pretty easy to just upload it to another place. So it's very difficult to take it away completely from the internet. Okay. A third issue is that of anonymity, which was actually mentioned, which is not only and not so much just an issue of making it difficult for the authorities to counter hate speech, because to a certain extent, it is often possible to go back to the source of the author of an anonymous content, also because oftentimes it's not people who are experts in technology. But of course, the issue is that we have, even if we could do that, theoretically, we have resource constraints, so it's not possible for the police to just go and find whoever on the internet posts hateful content anonymously. And also, anonymity is a huge issue from a psychological perspective, because if you are acting anonymously, you feel more at ease with expressing hateful opinions, more at ease at insulting people. You also have the idea of being distanced. From a psychological perspective, it makes it more difficult for the person speaking to feel empathy towards the person who is targeted. And then the issue of the transnational nature of hate speech, which is quite problematic because it raises issues of cooperation between various states. And that is problematic if we are talking, for example, of American platforms. Because as I was saying before, the US First Amendment protects freedom of expression and protects hate speech. And therefore, for instance, from a European perspective, we have to enforce laws against hate speech on platforms that are imbued in a culture of hate speech protected by the First Amendment. So you can understand that this leads to huge problems and huge challenges from a legal perspective. Then, another question which I would like to underline, to underscore. Online platforms are governed mainly by algorithmic tools, both for content moderation and content curation, where content moderation generally refers to the removal of hateful content, of illegal content, the blocking of accounts, the adoption in general of measures against to counter hate speech or illegal content. These measures are often adopted by online platforms based not so much on legal instruments, but on their standards and conditions. The issue of content curation concerns another aspect, which is the structure, the way that an online platforms tend to present to you the content it contains. So when you are looking at your feed on Instagram, TikTok, and Facebook or whatever, that content is generally presented to you in such a way as to try and present you with the content you are interested in. The goal is ultimately that of maximizing the engagement of the recipient of the service, of the user of the online platform. And this can determine quite big issues, because content like disinformation, but also hate speech, tends, because it's so controversial, it raises so much debate, that it tends to maximize engagement. And so oftentimes the algorithms on social networks, on online platforms, tends to make it more available to disseminate more easily content that is hate speech. So that is also a huge issue which must be faced by regulators when dealing with hate speech. Not only the issue of removing hate speech, but also trying to understand how we can try and reduce the exposure of the public to that hate speech content that is there. Also, a related issue, by the way, is that of biased algorithms, of algorithms that tend to discriminate themselves, people. I have an example which I oftentimes use. There is a very interesting article about some researchers who took a system, a software for hateful content moderation developed by Google. They took this software and then they also created a database of tweets by white supremacists and by drag queens who had participated in RuPaul's Drag Race. I don't know if there is anyone amongst you who know what RuPaul's Drag Race is. It's basically this talent show of drag queens, and I must admit my personal guilty pleasure. And so they took this set of tweets by white supremacists and a set of tweets by these drag queens, and they realized that in many cases the tweets by the drag queens were considered more or equally toxic than those of white supremacists. Why so? There are a number of reasons. It was partially the issues were already talked about today, but the way a content is formulated, the words used, the expression used, the language adopted, sometimes tend to have double meanings or different meanings, which a machine finds difficult to understand. So if I write, for instance, a tweet with no slurs, with no bad words, saying, in James Bond's films, you never see James Bond asking for permission to kiss a girl. So I advise you men to never ask for consent when kissing women, and women will actually thank you for that. So in such a tweet, there are no keywords, let's say, that could be interpreted by the algorithm to, or it requires additional technologies, very advanced technology for the algorithm to understand what that phrase actually means and what it entails. On the other hand, a post from a drag queen saying, a transgender drag queen writing, this tranny is enjoying her fag. Now, I have British relatives, so for me fag is generally a cigarette. But of course, you know that it can have a very different meaning. And so this phrase basically said, I am smoking my cigarette and I am enjoying my cigarette. That phrase was recognized as 95% toxic, something like that, whereas the phrase I told you before was around 15%. So you can understand that this leads to enormous problems when it comes to countering hate speech. Because in my opinion, and I think that maybe you will share that, the fact that we have instruments to cut down hate speech, but these instruments risk cutting down the speech of those groups that we should be protecting is a counter effect, a collateral effect, which is highly problematic because this makes it difficult to adopt forms of counter-narratives to fight stereotypes, to fight discrimination. Also take into account that in many cases, the use of certain slurs has been adopted by those victimized minorities as a way to reappropriate those terms. Think of the N-word for African American people who might use it as a way of reappropriating the term, of removing its toxic content, okay? The fact that the algorithm is not capable of understanding who is speaking in that case makes it a huge problem because we end up having all content by African American using the N-word cut down automatically. And this applies to many minorities, also sexual minorities. Now, to move on, okay, so, well, just to give you a brief overview, traditionally speaking, we have had approaches to speech governance and hate speech governance, which has focused on the speaker himself. Okay, so if you say these things, I state will punish you. This can apply to hate speech, it applies to defamation, it applies to any forms of crimes that entail a speech act. Now, what has happened in the last few years, because institutions have realized that it is impossible actually to ask the state, police forces, the magistrature to act on every kind of illegal content just because of the sheer amount of content we now have on the internet, there is a shift in these years from what has been called as old school speech regulation to new school speech regulation. That basically means that the European Union especially is now trying to responsibilize not so much the speakers, but the online platforms, imposing a series of obligations, of duties upon online platforms to adopt measures to remove illegal content such as hate speech, for example. Now, I will not talk about the European Court of Human Rights system because of time constraints. I don't know if this... I will, of course, leave the slides to you, so if you are interested in going a bit more into the legal aspects, you can have a look, and of course you can email me when you want, and we can have a talk about it. Let's move to the European Union framework. So, from a hate speech perspective, a very important act is that of the framework decision 2000 number 913 of 2008. Just to make it very short, this framework decision is very important because it has imposed on member states a harmonization of hate crime and hate speech criminalization, based, however, only on grounds of ethnic, racial discrimination and religious discrimination. If I have time, I will explain to you why it's only limited to these grounds. But this is to tell you that we have this limited intervention of the European Union. And this is important because upon this framework decision, some measures, some strategies have been adopted by the European Union to fight specifically hate speech online on these grounds. Okay, so first of all, we've had in May 2016 the so-called Code of Conduct on Illegal Hate Speech, which is a first example of this new school speech governance strategy that I was talking about. It is basically a code of conduct which was signed by the European Commission together with the major online platforms, Twitter, Facebook, and so on and so forth, Microsoft, etc. And in this self-regulatory agreement, all these platforms, all these IT companies undertook some commitments to, let's say, guarantee the reduction of hate speech online. Now, of course, the notion of hate speech, once again, is based on the framework decision of 2008. So the this self-regulatory instrument, this code of conduct, only applies once again to a specific set of hate speech acts. Also, I will be, just to put it very bluntly, studies have shown that the success of this code of conduct was a bit, it didn't work that well. Okay, just to put it very bluntly, it's there. There are some commitments that are followed sometimes. There are some reports about it, but the effect is not that brilliant. But I think you can also realize that from how much hate speech there is online. So it's quite self-evident. This we can skip, definitely. Now, this is a very important regulation, and it is what I would like to talk about to you, because the Digital Services Act is a very new regulation of the European Union. A regulation is, under European Union law, is a legislation, a piece of legislation, which applies directly within all member states. So this was approved, and this entered into force within every member state of the European Union. Okay. The Digital Services Act was adopted definitely in October 2022, so 1 year ago. And it aims to reform, in general, the content moderation practices of online platforms. It does so by introducing a set of new due diligence obligations for providers of intermediary services. That means that from the moment when this regulation will start to apply, because of course there is a time frame in between the approval of the act and the start of the application, online platforms will have to comply with a whole new set of obligations, which will touch also upon the issue of hate speech. Okay. Now, the interesting part of the Digital Services Act is that it does not treat all online service providers in the same way. Okay. So there are a set of rules of due diligence obligations that will apply to all providers of intermediary services. That means also services that just give you access to the internet, services that are used to transmit a message from a place to another, from an account to another, and so on and so forth. Then we have a second layer of obligations that will apply to hosting services that are the providers of hosting services are those providers that give you a space, a place on the internet to host your content, okay? So you upload your content, and that is a hosting provider. We have a third layer that is that of online platforms, and in this case, online platforms are all those websites that host your content and are aimed at disseminating your content throughout the rest of the population to others. And then we have very large online platforms that are these online platforms that keep up your content and disseminate it to the public, that have a certain number of users in Europe. Of course, Facebook, Instagram, TikTok, and so on and so forth fall into the very large online platforms. And actually, I was talking to you about the moment when the Digital Services Act will start being into force. Now, obligations for the first three categories have not yet become applicable. But with respect to very large online platforms, the regulation provided for the beginning of the application, for an anticipated beginning of the application, and that was on the 25th of August. So from the 25th of August, the DSA applies to very large online platforms, so to all the major platforms. Now, not to take too much of your time, but this will have some impact on the rights of users across Europe. First of all, there are rules concerning terms and conditions. So, for instance, platforms and in general providers of intermediary services will have to provide very clear norms, very clear standards and rules of conduct upon their services. And these rules, these standards and conditions will have to apply in a manner that is respectful of the fundamental rights as protected by the Charter of Fundamental Rights of the European Union. So hopefully, but we'll see how that works out, hopefully this should also apply to the right to equality and the right to freedom of expression, and should therefore represent a form of protection also for minorities, for victimized minorities who tend to be subjected to those biased algorithms I was talking about before. Hopefully. Then, as everything with the law, you have to hope that things will actually be applied in the right way. But apart from that, there are also some new provisions concerning the adoption of a notice and action mechanism, based on which, for instance, the platforms will have to respond in a timely frame to any flagging of illegal content. And most than anything, these very large online platforms will be required to put in place a risk assessment and risk mitigation procedure by which they will have to make some studies to understand how big is the risk of, for instance, illegal hate speech, and in general illegal content, disinformation is going to be spread across the platforms, and these very large online platforms will have to take adequate measures in order to reduce these risks. So this is why I was telling you that the goal is that of responsibilizing those platforms rather than punishing the speaker. So the goal here, and we'll have to see if it works, is to have the digital platforms respond and take more action against hate speech. Now, okay, just a quick last comment, then I'm going to close it. Now, I've been talking about all these new rules. Now, a big issue emerges with respect to hate speech, however. That is, the DSA does not talk about hate speech specifically. It talks in general about illegal content. Illegal content is to be understood based on the framework of the EU, so EU legislation, or the legislation of the member states. The problem here is that, as I was telling to you before, hate speech under the EU framework only applies to a very specific set of cases, so only to hate speech based on ethnic, racial and religious matters. It does not apply to any other grounds of discrimination. And why is that? It's because of the treaties. The European Union can only legislate, can only adopt legislations on matters that are contained within the treaties that founded the European Union, because, you know, member states are all sovereign countries, and when they came in together, they delegated some matters to the European Union. Criminal law is not amongst those matters. There are only a very few crimes that are considered of supranational importance, that are therefore subjected to criminal harmonization across the member states. Only in those cases the European Union can adopt measures, and this is indicated by Article 83, paragraph 1 of the Treaty on the Functioning of the European Union. So what is the European Commission trying to do now? It's trying to modify that article in order to include also hate speech and hate crime, and in that way, hopefully in the future, we might have an harmonization at the European Union level concerning also the regulation of hate speech, and in that case, we might have the opportunity of having the DSA and all this set of rules apply also to other grounds of discrimination. And I really hope this wasn't too strong. I am totally available for any Q&As. Thank you very much.
Yeah, thank you very much. Super interesting. So did I understand that right, that there are still certain local law regulations that are considered hate speech in Germany, for example, the denial of the Holocaust, that would not be covered to be ensured through the DSA to be covered by the platforms?
Okay, so yes, it depends from member state to member state. So I'm not fully, I do not know completely well how the legislation is in Germany. I think that in Germany you have section 130 of the German Federal Criminal Code. I can't remember whether that applies also to sexual orientation, gender identity or whatever, but the issue is that, yes, there will be some areas that will not be covered, because if you rely on the notion of illegal content, and that notion of illegal content relies either on European Union law or member states law, since we do not have a EU framework right now, for instance, in Italy, it will only apply to forms of hate speech that concern ethnic or racial discrimination. So yes, that is actually a problem, because there will be no uniformity also across member states from that perspective.
Yeah, I just wanted to remark how interesting is that this is the EU framework, but it technically affects the whole world, because if now, for example, it's happening with Twitter. Elon Musk has wanted to make many changes to Twitter that he can't make because it would be illegal here in Europe. So he hasn't been able to make a lot of changes. So yes, it's the European framework, but technically it's affecting the whole world.
Absolutely, absolutely, and that is also a big issue which is being debated, because a lot of platforms, since they are US-based, they keep on going on about the First Amendment, because in the US there's this reverence towards the First Amendment, which is very big. And so, of course, there is the issue of the transnational effect of this regulation. There is also some argument, and this relates also to what happened after the GDPR was adopted, the regulation on privacy and data protection, that it was showcased, it was studied that in many cases platforms which are active globally, in some cases when adopting to the rules of the GDPR, ended up amplifying the scope of these rules also to other countries. So once you have adopted measures to protect privacy in Europe, it is quite easy to just transpose it also to the US, for example. And so this is what is being called the Brussels effect of the GDPR. So the fact that we've had a regulation in Europe from Brussels, and it has had effects worldwide. And some are saying maybe the DSA will have the same effect, because of course online platforms are global, they're not localized.
So, is there any other question? No? Okay. So thank you so much.
Thank you.
Thank you.